Hello, I am Robert N. Davis, the 9th Chief Judge of the United States Court of Appeals for Veterans Claims. It is my distinct privilege to introduce you to the newest federal court in the country, and a court that uniquely stands at the intersection of law and medicine. In 1988, Congress enacted the Veterans Judicial Review Act, which remarkably, for the first time in nearly 100 years, gave veterans the right to seek relief outside of the Veterans Administration by appealing the agency decision to a federal appellate court. The United States Supreme Court has observed that until 1988, the Veterans Administration stood in splendid isolation as the single federal administrative agency whose major functions of granting or denying benefit claims by uniformed service members were explicitly insulated from judicial review. Without a doubt, the creation of our nation's youngest federal court provided long overdue justice to those who have served in the most dangerous way. For 3 decades, the court has strived to provide that review in a full, fair, and prompt manner. As you watch the video, keep in mind that the appellant, the person appealing the final decision from the Department of Veterans Affairs, is a veteran of the armed forces or a survivor of that veteran. If you are viewing this at a law school, you are about to observe a session of the court at which you will hear lawyers argue a case on the court's current docket. You will see that although this court is one of specialized and exclusive jurisdiction, the issues that we must decide range far beyond issues unique to the law of veterans benefits. Most of the cases involve procedural questions, statutory and regulatory interpretation, administrative law principles, and even constitutional issues. On behalf of the judges of the court, it is a pleasure for me to introduce you to the United States Court of Appeals for Veterans Claims.
The first thing that occurred to me is this is a court that has been created out of whole cloth. There has been no antecedent entity for it, as there often had been throughout the history of the judiciary in the United States.
It's been a kind of a dynamic evolution. The court was established in 1988 by Congress as a specialized court reviewing the final decisions of the Board of Veterans' Appeals. Prior to that time, there had not been judicial review for veterans over their claims for VA benefits. And so it was a new experience for everyone.
The challenge to start a court from scratch, if you will, was just irresistible.
The VA opposed the creation of the court. They opposed judicial review in the 1980s when it was being debated in Congress. I think the people at the VA since then, most of them agree that the court is a good thing.
The most significant change that has taken place as a result of judicial review is that someone is looking at what the Veterans Administration, now the Department of Veterans Affairs, is doing. Prior to that time, the VA itself was simply reviewing its own quality of decision making. Now those decisions are subject to review by judges, sometimes a single judge, sometimes a panel of 3 judges, and occasionally the court sits en banc. As a result, we now have what is called jurisprudence in the law, and we have precedential opinions that explain to the VA and to the Board of Veterans' Appeals exactly what the law means, how it should be interpreted, and more importantly, how it should be applied to the benefit of veterans and other claimants seeking VA benefits.
I think that everyone would agree that the court has lived up to expectations, is a vital part now of the process that ensures that veterans not only get the benefits that they deserve, but also get the fair process that they deserve and expect.
This court continues to build on the groundbreaking work of the court's first Chief Judge Nebeker, and his successors, the judges, the clerks of the court, and the diligent staff who support them. In its first 20-plus years, the court has achieved incredible successes. This court's operations are now paperless. Our docket is web-based, and oral arguments that are conducted across the nation can be heard through audio streaming over the internet via links on our court's website. Over the course of the last decade, the number of cases filed at the court has increased twofold. This growth and the significance of veterans law has drawn thousands of new members to the court's bar, and our court's bar now includes over 4,000 attorneys and non-attorney practitioners. Going forward, we continue to develop innovative techniques to help us address our expansive caseload, and I can give you no better example than the staff conferences conducted under Rule 33 of the court's Rules of Practice and Procedure. These Rule 33 staff conferences have been extraordinarily effective in streamlining the appeals process and in leading to the expeditious disposition of cases.
Our staff attorney will call the two other parties, the appellant's counsel and the secretary's counsel, and basically discuss the case that has been presented to us from the appellant's counsel. They submit summaries of issues, which is basically a statement of what the attorney believes is the problem or a number of problems in the case. That statement of the issues is submitted to the secretary's counsel. He or she evaluates that 14 days before we actually conduct the conference, so everyone is informed as to what will be discussed and is better prepared to discuss the issues.
Where a veteran comes to the court pro se, they don't have an advocate who is skilled in litigation, looking out for their interests. They may not understand the administrative process or the legal issues or the best way to present their case, the most effective way to present their case. And so a pro se appellant is usually at a disadvantage. The judges recognized that early on and helped organize a Veterans Consortium pro bono organization, which tries to place cases with pro bono counsel in the Washington area or even nationally.
It is an opportunity to represent people who have served the country by putting themselves in danger. Those who have suffered the consequences of that are those who are claiming, for the most part, benefits from the Department of Veterans Affairs. And so it's very rewarding. Another aspect of the pro bono work is, particularly again for young lawyers, is the opportunity to become involved in a really important case with a real client, to write a brief, to do an oral argument, and to make some law.
There are a lot of career opportunities for attorneys that have been created because of the existence of the Veterans Court. For example, the Veterans Court itself hires law clerks, which is a great thing to do after one leaves law school. But also it creates the opportunity for someone who's interested in this area, who wants to help out veterans, who wants to make a difference. They can come to the Department of Veterans Affairs. There are service organizations that work in this area. There are law firms that are very active in veterans benefits law, and it's a really interesting area that I think has grown because of not only the establishment of the court, but because the court has been a pioneer in creating opportunities, getting the word out to the law schools and the public that veterans are underrepresented, and there are a lot of opportunities here in this new area of law.
But in terms of professional satisfaction, there is just nothing that equates to it. And on a personal level, the feel-good that you get when you realize that you made a difference in that individual's life or in the family's life as a result of your efforts, it simply can't be quantified.
The court has made decisions which have, in many respects, revolutionized veterans law. There is a much higher probability that a decision rendered by the Department of Veterans Affairs will be in accordance with the statutes and regulations than was the case before the court came into existence.
The court has made a profound difference in how the VA operates. It has not been perfect. There is a lot more work to do, but the court has made a material difference in the lives of veterans.
We appreciate the significance of this court to our nation's veterans, and we strive to ensure that the case review process is thorough and meticulous. The judges of this court and this court's team of professionals want to get it right, and they want to get it right here.
I hope that you found this short video informative. Even though judicial review for veterans has existed now for nearly 30 years, This area of the law, in many respects, is relatively new frontier. More and more attorneys are devoting their legal practices exclusively, or almost exclusively, to the law of veterans' benefits. Others are volunteering to serve as pro bono representatives, seeing an opportunity to provide tangible and meaningful assistance to veterans and their families while gaining valuable experience by appearing before a federal court of appeals. For those who would like to enter this field in whatever capacity, Congress has funded a program that recruits, educates, and supports those who would like to represent veterans. The court's rules also permit law students to appear before it after their first year in law school. What a great way to begin one's career. I love the work that I do here, and I am honored to serve the nation in my capacity as the Chief Judge of this court.